Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good day I wish to everyone who is watching this video, especially to Professor Madhya Dr. Haji Muhammad Shanawi Muhammad Pirus. My name is Muhammad Lutfil Hadi bin Muhammad Najib, and my student ID is 2024284294. Today, under the subject of INC500, Industrial Relations, Regulations, and Cybersecurity, I'll be reviewing a legal case on the matter of cybersecurity involving Creative Purpose Syndrome Berhad and another versus Integrated Trans Corporation Syndrome Berhad and others, which took place in 1997. So a quick summary of this case is that it touches on how copyright law protects software and security features. It also ensures that technical access cannot be circumvented, which is the legal term for hacking, without proper license. So before we dive deeper into this case, let's get to know the plaintiff and the defendants of the case. So the case name is quite long. So the first plaintiff here, it refers to Creative Purpose Syndrome Berhad, and the second plaintiff here refers to another, which is the corporate parent of the company. The defendant here consisting of three defendants. The first defendant is Integrated Trans Corporation Syndrome Berhad, and others here refer to the other two defendants, which is the second defendant, a company described as a customer support of the first defendant, and the third defendant here refers to someone or a person that the plaintiffs claim to participate in modifying the software or the program. So these three defendants were said to share registered addresses and common directors among them. So let's get to know the background of the case before we move to the facts of the case. So Creative Purpose Syndrome Berhad and second plaintiff mutually own and developed the MEP payroll software and its upgrades. So the upgrades had variants like 3.30 until 3.33. The program here was sold as a package of two diskettes, a loader and also the main program. The loader here contained protection code that checked for a copy protection device. So the second point of the background of the case is Integrated Trans Corporation Syndrome Berhad and others, which are the defendants of this case, formerly functioned as a support arm responsible for servicing customers, but not for copying or distributing the software. So in simpler terms, the relationship between these two companies have existed before the case occurred. So they are no stranger to one another. They are familiar with one another. However, even though they are familiar with one another, the defendants here were never given a code to enter the system. Moving on to the facts of the case here concerns EC or MEP payroll software, which as I've mentioned previously, dated to version 3.30 until 3.33 that was sold in two disks and updated through upgrade disks. Originally, the system used a key diskette to program it. However, it was later upgraded to using a dongle, including a specific source code. So in cybersecurity or in computer language, source code here refers to a code that was written by humans that can be read by computer. However, there are also a second code which is object code. Object code here refers to a code that can only be understood by the computer. So the plaintiff's upgrades, including versions 3.32 and 3.33, contain new coding and features, qualifying them as original works deserving copyright protection. For version 3.32, in January 1995, they added further coding that made certain features like text deduction feature accessible only if the dongle check passed. So version 3.32 ensures stricter dongle checks to access payroll features. The plaintiffs here claim that the defendants copied and sold MEP 3.32 and 3.33 particularly and circumvent, which is hacking the dongle by modifying the program files. So the plaintiffs also pointed to copyright notices and evidence that developers, which are the employees, had created the latter versions. So the defendants here deny alleged infringement. They argue three main points. The first one is some versions originated with the earlier company. The second points they argue, which are the defendants had an oral distributorship or maintenance agreement with the company since 1987 and give an implied license to make copies or modify for maintenance purposes. And the third issue they argue are upgrades were joint works or otherwise not original to the plaintiff. They also argue lack of evidence implicating the second and the third defendants of this case. So Sees this and labels from the Anton pillar search connected the defendants to the copied and distributed software. So what is an Anton pillar search? An Anton pillar search here refers to a special court order that allows one party to enter the other party's premises without prior warning to seize evidence that might otherwise be hidden, deleted, or destroyed. So in this case, the plaintiff had formally requested to the court for an Anton pillar search to be taken. So moving on to the issues of the case. So the issues of the case are as follows. The court had to decide whether the software was protected by copyright, whether there was infringement involvement, whether the ownership in the copyright vested in the plaintiffs, whether the improvisations could attract copyright, and whether there was an implied license, which take us to the judgment of the case or the decisions of the case. The court favored in the plaintiffs in which the dongle and software were legally protected by the copyright. This aligns with Section 3 and Section 7 of the Copyright Act 1987 to include all manifestations of instructions readable by a computer, including the codes that I have mentioned previously, which are source code and object code. Therefore, the dongle software component is protectable. Second judgment of the case is the court ruled that the defendants had indeed modified, copied the software illegally while having no implied license. The court also ruled that hacking the dongle sufficed for infringement even without literal code copying. So this matter, the court had taken three precedent cases, which are the first one is Ipcos Computers Limited versus Barclays Mercantile Highland Finance Limited and Alibert SA versus O'Connor, which these two cases confirms and establish that the first one is computer programs which include both source code and object code are literally works protected by copyright, and each updated or revised version like MEP 3.30 until 3.33 can have fresh copyright if sufficient effort is added. The court also applied the sufficient skill and labor test, which evidence showed programmers inserted thousands of lines of codes and new commands under under the upgraded features. And under the Section 7, Subsection 2, and Subsection 4, even if earlier version existed, a sufficiently original upgrade gets its own protection. So versions 3.30 until 3.33, and in particular 3.32, 3.33 were found to be original enough to attract copyright. And following authorities' cases like Autodesk Inc. versus Dyson, the judge held that circumventing a copy protection device by patching loader and main program is an act of infringement even if the defendant didn't literally copy the source text line by line. The amount of compensation or damages to this case were to be assessed later. However, the court here gave a permanent injunction to the defendants. So permanent injunction here referred to a restraining order by on the defendants and associated persons from modifying, reproducing, distributing, or selling the plaintiff software. Counterclaim of the defendants were dismissed like implied license or that they were joint authors uh, because it was lack of credible evidence and the infringement was already proven. So these are my analysis and the critics of this case. The case shows how long-term technical cooperation without formal licensing could later lead to misunderstanding and conflict. Although the defendants previously worked as a support arm to the company, their role never legally approved to copying or distribution. So here the defendants had customer servicing access, but no source code or duplication rights because it was never given to them, and responsibility here between the two companies were not expressly documented. So these two companies are working or operated in a gray area until infringement occur. So this highlights lack of boundaries and unclear scope of tasks between the companies. The court's reliance on ownership under the Copyright Act 1987 provided certainty, especially where multiple entities contributed to development. However, while the court accepted version 3.32 and 3.33 as original, the case signals how easily software development history can become disputed when work evolves over years and across company. Therefore, each software upgrade should be paired with proper authorship records to prevent ownership confusion. And also, the case supports cybersecurity integrity by treating security tools like dongles as an important legal mechanism. So this case marks an early recognition that dongles are more than just technical barriers. And also, the Anton Pillar request shows the necessity protocol of early evidence preservation in digital infringement cases. Why is it important? Because the Anton Pillar order was crucial because software infringement evidence is easily deleted. So digital internet protocol cases like this require a very swift intervention by the court because many cases like this could collapse due to lack of proof. And also, my last critique of this case is the defendant's claim of an implied or oral agreement showcases why verbal arrangement in software servicing relationship can become limited in legal case. So, wherever there are dispute, the defendant should document the evidence properly. So these are the references that I use for this case. The first reference is obviously the case itself, Creative Purpose Sdn Berhad and another versus Integrated Trans Corporation Sdn Berhad and others, which took place in 1997. The second until fourth reference are the precedent cases, which are IPCOS Computers Limited versus Barclays Mercantile Highland Finance Limited, which took place in 1994, which is a United Kingdom case. The third case is Autodesk Inc. versus Dyson, which took place in 1992, which is an Australia case. Albert's SA vs. O'Connor is an Ireland case which took place in 1981. Although these three cases are not Malaysian, these are used as a precedent cases because such principles from the case established have been discussed in order to align with the Commonwealth decisions. And also, the last reference that I use for this case is the Copyright Act 1987. With that, I end my presentation with Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Thank you so much for listening.